Great.
Okay, good afternoon, everyone. My name is Lisa Lieben, and I'm the Risk Management and Training Coordinator here with IRMA, and we are proud to present our police reform legislation workshop. We have a very knowledgeable panel here today to go over the legislation and answer any questions that you may have during this time. Uh, because time is tight, as each of our presenters go over their section of the legislation, just a couple of housekeeping items. We are going to have the chat box as well as the Q&A box monitored. So if you do have questions while they are presenting, please put them in there. We'll read them as we're going through the afternoon. If time allots, or we'll try to answer all of them in real time, but if things start to get a little close and we're concerned for time, we will hold questions till the end. Also, as you do exit this webinar today, there will be a evaluation that we ask everyone to fill out just to let us know any content questions that you have, or any follow-up that you would like us to do with you individually. We can do that as well. Just make sure to put any comments in the evaluation form, and we'll make sure to get back to you. I am going to turn this over to our moderator today, that is Susan Garvey, the Director of Legal Services with IRMA. Thank you.
Great, thanks, Lisa. Good afternoon. Thanks for joining us today. We're really excited to present this workshop on the new legislation. We have five, as Lisa mentioned, five great speakers. They're going to share their perspectives on different aspects of the bill. Obviously, we can't cover everything, but we're going to do our best to hit the high points. So I'm going to introduce the speakers. The first speaker we have is Bernie Hogenkamp. He's a retired sergeant after 30 years with the Homewood Police Department. He's currently serving part-time with several agencies, and he provides a lot of training. He retired as the watch commander of the afternoon watch, supervised the investigations tactical units, as well as serving as a team leader on the South Suburban Major Crimes Task Force. He's a state certified instructor. He teaches and trains officers in defensive tactics, impact weapons, firearms, active killer response, bike patrol force reporting, use of force, and instructor courses in use of force and other areas. Since retiring, he has served as the president of the International Police Mountain Bike Association. He's the current president of TBL Training Corporation and a manager of event security for the Chicago White Sox, the Bulls, and the Blackhawks. Bernie is going to provide his perspective on the use of force considerations. We also have Bob Berlin, the DuPage County State's Attorney's Office. He will be our second speaker. He has been a career prosecutor for 33 years. He began as an assistant in the Cook County State's Attorney's Office. He moved to the Kane County State's Attorney's Office, and then the DuPage County State's Attorney's Office, where he has been the big guy since 2010, where he was appointed and subsequently then elected. He has tried 87 felony jury trials, 58 which were first-degree murder. He's tried hundreds of felony bench trials. He's earned numerous awards and accolades. He's a frequent lecturer on a variety of criminal justice issues and has testified before the Illinois Senate Criminal Law Committee and Illinois House Judiciary Committee on numerous criminal justice bills. Bob is going to give us his perspective on the criminal and prosecutorial considerations of the act. Our third speaker is Yvette Heintzelman. Yvette is a partner at the Clark Baird Smith law firm. She represents public and private sector employers in labor and employment matters. Her expertise in labor and employment related matters include litigation in federal and state courts, administrative agencies, as well as grievance arbitration negotiations and unfair labor practice charges. She represents both public sector and private sector employers in the labor relations matters, as well as litigation. She has extensive experience representing public safety departments, and they rely on her to help them address labor and employment issues, to avoid litigation through a proactive approach to resolving various employment issues. Yvette got her bachelor's from Creighton University in Omaha. I lived in Omaha for a number of years, Yvette. And she graduated law school from Creighton University Law School as well. Yvette is going to give employers considerations, a perspective from the employers on this new legislation. Fourth speaker, Tamara Cummings. She is the general counsel to the Illinois Fraternal Police Labor Council. It's a large sector union representing law enforcement bargain units, all areas of labor and employment relations. She's a fellow of the ABA College of Labor and Employment Lawyers. She was in private practice, represented Chicago police officers in administrative, criminal, and civil matters. She received her bachelor's degree from the University of Chicago and her Juris Doctor degree from Washington University in St. Louis, Missouri. Tamara is going to give us a perspective from the employee. We have our final speaker is going to be Mark Maitan. He's the chief in the village of Lamont. He's going to provide us a perspective on the trailer bill, the changes that the Chiefs of Police Association is trying to make in this legislation. So he's been in law enforcement since 1986. His primary assignments have been drug units, multi-jurisdictional task forces. He was appointed the Chief of Field Operations for the Illinois State Police. In 2012 was appointed the Deputy Director of the Illinois State Police. January of 2015, he was appointed as the Chief of Police for Lamont, received his certification in 2016. He's currently the chairman of the Legislative Committee for the Illinois Association of Chiefs of Police and past president of our IRMA Police Chief Steering Committee. He's got his bachelor's degree from Northwestern University and a master's in law enforcement administration from Western Illinois. And he will be joining us later on, as I said, to go over the changes that the chiefs of police and other law enforcement agencies are trying to make to this legislation. So with that, I will turn it over to Bernie Hogenkamp to talk to us about use of force considerations.
Thank you. Good afternoon. We're going to start with a little disclaimer. I'm going to put up our statute, our 7-5. But my disclaimer is that I'm a long-term police officer, 40 years in law enforcement altogether, and not an attorney. So it's always a bit fraught to be in the presence of attorneys. Are we seeing the statute on the screen now?
Yes.
But I teach with attorneys, so perhaps that makes me a little bit smarter. And I think my role as an instructor in use of force and a variety of different force applications is to do the best I can to take what the statutes say and make them into something manageable for officers to come to an understanding of how to not just have a clear understanding of what the statutes allow and limit, but also to be able to interpret them in ways that they can actually use them. So I tell my officers in training that this understanding has to be a very deep understanding, perhaps even deeper than an academic understanding, because they'll be not only empowered, but be bound by it in real time. So when they make their decisions, as we saw in the case with split-second decisions in the Chicago 13-year-old case, very little time to do these things in real time. So we'll start with 7-5, which is the Peace Officers Use of Force statute in Illinois. And the first change, although it isn't evident in red, is that when a peace officer and a person whom he has summoned or directed to assist him need not retreat, we have a new clarification on the word retreat, not really a definition, but down here at the bottom of the page in red, as used in this subsection, retreat does not mean tactical reposition or other de-escalation tactics. It's a little bit opaque. I'm guessing the idea is that when we face resistance or threaten resistance, we certainly have the authority to go forward with the arrest. The resistance shouldn't necessarily stop us, but that somehow this ability to not retreat is perhaps something that we take too far, that we don't take de-escalation or tactical repositioning into consideration. I might argue that point, although there are times we don't do a great job of that. So I think they've added some sort of caveat to this need not retreat, but they've done so in a way that makes it difficult to grasp. I think the general idea is that we should slow down perhaps, and perhaps not do things like chase people down alleys with guns. As dangerous as that might be, I don't know that we could ever stop doing that. But in doing so, they really only define or alter the definition or clarify the word retreat. They don't say anything about desisting from efforts. So it isn't put together in a way that makes it really evident to me exactly what they're trying to say, except that somehow we should slow down, perhaps. Then the only changes in this first paragraph, and justified in the use of any force that we reasonably believe, this new wording based upon the totality of the circumstances to be necessary to effect the arrest in any force which he reasonably believes, based upon the totality of the circumstances, to be necessary to defend himself or another from bodily harm while making the arrest. This new language, I don't think, is a significant variation. We've always had this being an issue. There never has been an occasion where we're only going to bring forward some of the circumstances. And I wouldn't necessarily have an objection to this language, except that somehow they've decided, if we look further back down the line, they've created a new definition that I had never seen before. And perhaps someone with a legal background might characterize this better than I would, but they've now defined totality of the circumstance, meaning all facts known to the peace officer at the time, or that would be known to a reasonable officer in the same situation, including the conduct of the officer and subject leading up to the use of deadly force. There's some difficult language in here, and I think we're losing sight of not just reasonability, even though the language is in here, but also understanding when we say all of the facts known and we say same situation, those are difficult to characterize. If they had used the language that Graham used from the perspective of a reasonable officer on the scene, and going back to the language in our statute about reasonably believed, this reasonable belief allows for officers, this reasonable belief, particularly the word believe, allows for officer perception, understanding that in real time, there are going to be physiological and psychological changes that are going to affect how we perceive the world, how we see what we see, and whether anything even registers in our perception to the degree that we can actually make a judgment based upon that. So I have difficulty with this definition. I'd have preferred they simply left the term totality of the circumstances alone and allowed to stand alone, and to create some new definition that confuses the Graham standard, I think is not helpful for us. It doesn't help clarify things for officers. Justified going further. Again, we now add in under deadly force, still again based upon the totality of the circumstances. But other than that, our ability to prevent death or great bodily harm to ourselves or others is not diminished in any way. So I'm not necessarily concerned about the language here, except for this definition that I think muddies the waters up a bit. The force necessary to prevent, now they get then beyond this now, this is pure, essentially self-defense while making an arrest. So that is largely unchanged, except for this language with the totality of the circumstances and the additional idea that perhaps we should be tactically repositioning or de-escalating, which I think we're often doing anyway. But now we get into something beyond self-defense during the arrest. And now we have to reasonably believe both of the next two things. First, that the force is necessary to prevent the arrest from being defeated by resistance or escape. And now we have totally new language, so that the officer reasonably believes that the person to be arrested cannot be apprehended at a later date. And the officer reasonably believes that the person to be arrested is likely to cause great bodily harm to another. So before we go any further into the second feature of this, the second necessity, this first one creates some real difficulties for officers in the real world. There are certainly going to be occasions where, based upon the level of the offense, based upon the fact that officers know who the person is, based upon the danger of arresting that person in the moment and perhaps arresting them much more safely at a later time at a safer location, that those things would be very wise to engage in. But in this case, there is no caveat other than the person to be arrested is likely to cause great bodily harm to another. So this creates an open-ended idea that we could always be subject to the possibility that being apprehended at a later date could be the issue. And I see I have some real concerns myself, and I from those classes that I've taught since this language came out, of all the things that I'm seeing in the statute, this language is the most concerning to the officers that I teach. And they're fearful that they'll be subject to second guessing that their behavior is always subject to the idea that you really didn't have to do this now, that you didn't have to proceed with this arrest. You could have always waited to do it at a safer time and a safer location. And I think that's going to be a difficult hurdle for us to overcome. I'm hoping that in the trailer bill that we see some clarification of this, perhaps simply clarifying the language to include additional language that would say that if the offender is known and if circumstances allow, that an arrest at a later date at a safer location and a safer time with additional personnel and other factors that might come into play, that would be language I think officers could choose to be instructive. In this case, I think officers are looking at this as being likely to hold them to an accountability that will be difficult to live up to without unnecessary criticism for their choice in the moment. I'd be interested to hear what any of the other panelists would have to say about that if anybody wants to intercede. Or perhaps not. No? All right, let's continue on. Was that a question?
No, there's no questions at this time, Bernie.
Okay. So continue on. This is part 2. So again, we're going back to both of the next 2 things. So both these things, first number 1 and now number 2. And the person be arrested, there is new language. And it had previously been the person to be arrested has committed or attempted a forcible felony which involves the infliction or threatened infliction of great bodily harm. And in this case, there's language that creates some time frame on this. And the time frame, rather than saying it was immediate or had occurred in the immediate past, now interjects the word just and deletes the word has. I'm guessing the intention is that it should be something that has occurred in the very recent past, maybe the last moment or the last minute or two. But the language makes it difficult. In fact, it would have been even better to leave the word has in there. The person to be arrested has just committed. So inserting just after has might make more sense. But the word just isn't a great example of giving us a time frame. Is it immediately previous to this? Is it within a few minutes? I'm not clear on this at all. And the time frame is only included in this portion in this first sentence, because then we move forward beyond the first phrase of that sentence and we have an or, so the exclusive begins. And the part that I was concerned that they might actually alter or edit is this next section, or is attempting to escape by the use of a deadly weapon. And we train officers to understand that the use of the weapon is really only when the weapon is put in a position to be employed. So in other words, if it's a firearm or it's a knife, that it would have to be in the hand, not just in the pocket or in the waistband. And that would make some immediacy of use of that weapon. And the next consideration would be whether or not that weapon has a particular range that the officer should be feeling that they are in that deadly range. So a firearm certainly much farther than a knife, which would have to be a closer proximity. They didn't change this at all. So I'm somewhat surprised that this didn't get changed, but perhaps I shouldn't say that aloud very often and they might find reason to change it. Or otherwise indicates they who endanger more life or inflict great bodily harm unless arrest without delay. And that also is unchanged, so that we have the ability to end the pursuit or someone who is extremely dangerous and that we must not allow them to escape. And that still exists in the statute. So these sections that I was fearful that we might see restricted, that I don't see them. And when we train officers on this issue of escaping by the use of a deadly weapon, we also point out that this is a very rare occurrence. So offenders flee with deadly weapons regularly, particularly in our more challenged areas. But we rarely ever see an officer use deadly force against a fleeing individual without some other sort of behavior on the part of the individual. We saw it in the case of the 13-year-old in Chicago. He didn't shoot him as he fled, even though the weapon was visible in his hand. And he didn't shoot him even though the weapon was visible slightly to his rear, and just didn't instantly shoot him. So even though the statute by its direct wording would authorize that, officers rarely ever do that. And I have very few videos that I use for training that ever includes any of that sort of behavior. Then we have a whole new series of sections. So A5, this is all in dark blue. Where feasible, a peace officer shall, prior to the use of force, make reasonable efforts to identify himself or herself as a peace officer, and to warn that deadly force may be used unless the officer has reasonable grounds to believe the person is aware of those facts. So the idea that we can identify ourselves is not something foreign to us. Most officers will identify themselves. Even in uniform, they'll identify themselves and they'll shout out, police, stop, or police, you're under arrest, or police, drop it. They'll do all of those things. The thing that isn't in here is that there should be a caveat that should allow officers to not have to identify themselves when doing so would make the circumstances more dangerous to themselves or others. So there will be occasions where an officer sees deadly force about to occur, sees an individual about to harm another person, and all that would occur by calling out to them and saying police would be to allow time to pass and allow that continuation of the event to take place, so that they may only have time to prevent the use of deadly force on another by using deadly force themselves without saying anything. So the Tennessee versus Garner standard, where we are compelled to give verbal warnings when feasible prior to the use of deadly force, that feasibility is about the idea that it's about occasions where we may not be able to do that. And creating this feasibility as a factor here, even though the language is in here, it doesn't, I don't think, address very clearly what the concerns of officers are. Language could have been added in here that would have given officers some reassurance that failing to verbally identify themselves isn't always going to be necessary. And then the other issue is, I'm not certain how we can determine what reasonable grounds to believe that the person is aware of those facts. Is a uniform sufficient? Would be body armor saying police be sufficient? Or be simply saying police be sufficient? I'm not sure that's very clear. A10, a peace officer shall not use deadly force against a person based on the danger that that person poses to himself or herself. So in this case, and we'll continue on, but in this case, I think we're specifically talking about suicidal individuals. And it opened up the entire issue of officers dealing with individuals who have mental illness issues. And these are always fraught with difficulty for us. We have a great deal of difficulty putting ourselves in a position where a person could be about to use deadly force against themselves, but in some fashion, we go to the scene and try to connect with the person to a degree that we can convince them not to. The difficulty is that it's hard to be able to do that without putting yourself in danger. So how do we communicate with them without some measure of danger to ourselves? And unless we can talk to them on the phone and hold a position of cover, that could become very difficult to do. So we're seeing across the country, there are occasions that police agencies are abdicating their response to suicidal people who are only a threat to themselves or others. And I don't think most of us in law enforcement are comfortable with that idea. We feel some compulsion to help those who are mentally ill, but at the same time, the agencies that have started to not respond to those calls are doing so because of the occasions where it's gone badly and someone has forced the issue and caused officers to use deadly force to protect themselves or another, and then face civil and perhaps even criminal litigation afterwards. And officers are concerned about that, and we do use deadly force on individuals who pose a threat to themselves. So we're getting into an area where we are having a lot of difficulty, and the case law isn't very clear for us on what the standard would be. In our case, if we talk about the Graham standard, we're already well behind the curve. There is no severity of crime. They aren't resisting arrest necessarily or trying to defeat our arrest by escape. They're simply posing some danger that we could ameliorate by simply not being there. So we're creating a standard where officers may in the future be simply disengaging themselves from these occasions. I'm not sure that's what the public wants us to do. So if we continue with the language, danger that the person posed to himself or herself, if an, which isn't correct, reasonable officer would believe the person does not pose an imminent threat of death or serious bodily injury to the police officer or to other persons. So I'm not sure how comfortable our public will be with us simply not going to these calls or arriving on a person by themselves in a home that says they're going to kill themselves, and that we disengage and make no further effort to engage with them in some fashion. So this is going to create some problems for us that I think the legislators that wrote the statute really didn't contemplate. At the same time, I do hope, and it's not something that it's something that we do cover in the classes that I teach, is that we really ought not to be engaging in circumstances that we force the issue, that we don't necessarily have the training to talk somebody out of killing themselves, and that putting ourselves in clear deadly danger is going to force the issue in ways that perhaps we don't want to force. So that's not something we have neglected to train. We've been training this for a long time, and we'll continue to do so in spite of the statute. A15, peace officers should not use deadly force against a person who is suspected of committing a property offense unless that offense is terrorism or unless deadly force is otherwise authorized by law. I don't know of any occasions where officers are using deadly force against a person who committed a property offense. I'm not certain what the basis behind this is. On occasions where it rises to a level of deadly force, it's a consequence of other actions that occur afterwards. An officer is trying to arrest somebody for a misdemeanor offense or a property offense, and it turns into deadly force because of the behavior of the individual. So they're not arresting them for the property offense any longer. They're arresting them for the issue of posing some deadly danger. And I'm not sure what the idea of including terrorism in here is of any instructive nature to us. Section B is the same as it had been. That was unchanged. So the warrant is invalid. It doesn't change anything as long as we don't know that it's invalid. Under C, the authority to use physical force conferred on peace officers is a serious responsibility that should be exercised judiciously and with respect for human rights and dignity and for the sanctity of every human life. We're seeing that showing up in policies, particularly Lexipol policies, and I don't know of any officers that have any objection to this. In fact, I would even submit the possibility that there isn't an organization or a group within our public that has a greater sense of the seriousness of the responsibility that officers share in dealing with these sorts of circumstances. And then D, peace officers use deadly force only when reasonably necessary in defense of human life. Well, that's right out of 7-5 in the beginning of the statute. In determining whether deadly force is reasonably necessary, officers shall evaluate each situation in light of the particular circumstances of each case and shall use other available resources and techniques if reasonably safe and feasible to a reasonable officer. Again, no new information, simply a restatement of the setup to the Graham standard. So nothing new or particularly concerning about this language. It's part of what we teach officers in their using good judgment. The decision by an officer to use force should be evaluated carefully and thoroughly in a manner that reflects the gravity of the authority and the serious consequences of the use of force by peace officers in order to ensure that officers use force consistent with the law. And nothing really new there. Again, these are all things that are in policy, particularly Lexipol policies. I'm going to move forward. I think my time is running a little bit short. So none of these sections that are in here are particularly concerning. They're all parts of the new statute, but they're simply recitations of language coming out of case law and Garner that don't necessarily create any new higher standard for us. So if nobody minds, I'm going to move forward a little bit further. Law enforcement agency are encouraged to adopt and develop policies for people with physical, mental health development, or intellectual difficulties. Those are all parts of current new policies that are coming out as well. But then a whole area of concern is when we talk about under one here, we're adding the term serious bodily injury. That is not what the terminology that we use in Illinois statutes. We use great bodily harm. So I have seen in the trailer bill that there hopefully will be changes to use the language that we are customarily used in the statute. And then this threat of serious bodily injury or death is imminent when based upon the totality of the circumstances. Reasonable officer in the same situation believe that person has the present ability, opportunity, power, and intent to immediately cause death or serious bodily injury. Well, this language is very convoluted. Again, the new language in here with serious bodily injury, but even more important, we're using two separate words to relate an understanding of time, and imminent and immediate are not the same thing. The standard in our statute, the standard in Graham and Garner is immediacy. It isn't imminent, with very few exceptions. So to include the word immediate in a definition of imminent is very confusing. I'm certain it's not just to me, but to others as well. And then this imminent harm is not merely fear of the future harm, no matter how great the fear and no matter how great the likelihood of the harm, but is one that from appearances must be instantly confronted and addressed. And again, using the term imminent and then later instantly confronted, we're using imminent and immediate response in the same sentence. Very confusing to me, and I'm guessing just as confusing to others. Under prohibited force, 7.5.5, this statute was originally set up in 2016 regarding chokeholds. So we'll start with the definition. Under C, as used in this section, definition of chokehold means applying any direct pressure to the throat, windpipe, or airway of another. And the language that included with the intent to reduce or prevent the intake of air is gone. And the chokehold does not include any holding involving contact with the neck that is not intended to reduce the intake of air. That was a carve out that would have included the lateral vascular neck restraint or the blood chokes that officers could have continued to do. Not something that I taught. I think it's problematic for law enforcement for a variety of reasons, not something that I have taught in many years. So that's gone now. So a chokehold is simply direct pressure to the throat, windpipe, or airway of another. And then new language in a peace officer, any person acting on behalf of that officer. I don't know why that was added. What other person would be doing something on my behalf? I'm not certain. Shall not use a chokehold or restraint above the shoulders with risk of asphyxiation in performance of his or her duties. So now we've included anything above the shoulders that would have the risk of asphyxiation unless deadly force is justified. So now we've expanded this definition of deadly force, including restraint above the shoulders. But now under D, which is a whole new section, we have a contradiction. As used in this section, restraint above the shoulders, the risk of asphyxiation means use of a technique used to restrain a person above the shoulders, including the neck or the head, in a position which interferes with the person's ability to breathe after the person no longer poses a threat to the officer or any other person. So based upon this, which conflicts with the first part, making it deadly force, you could use a technique while the danger continues. So if the threat is still posed and the person is not yet in control, and then when that person is no longer a threat and control has been gained, you would have to stop the use of that control above the shoulders. So contradictory. One case we call it deadly force, another case we define it with a more open definition. So it creates a conflict in our officers' understanding. And then none of these things down here is new except for one in particular. It's new, but it isn't really new for us. Use of behalf of an officer shall not use force as a punishment or retaliation, always been unlawful. Discharge a kinetic impact projectile and all other non-lethal projectiles in a manner that targets the head, pelvis, or back. We have a whole new, this whole new section in here creates a problem for us for the use of the taser, since it is a projected, less lethal weapon, and the back is now the preferred area for the use of a taser, the safest location for a taser. It might also be appropriate that a less lethal weapon like a beanbag or a from beanbag shotgun or a 40 millimeter round might be used very effectively in a case where we would use a less lethal weapon, even though deadly force might otherwise be authorized. So I'd like to share a video. It's very brief. It's a video where we have an individual who is suffering from a mental health issue. He is suicidal, and he is holding a gun to his head, and officers are there, including SWAT officers in an armored vehicle. And they've chosen to use a 40 millimeter round to stun him in the hopes that he will drop the weapon. This has gone on for quite some time now. I'm going to start it as he walks down a pathway, and you'll see the command vehicle move forward. He's still holding the gun to his head. Officers are maintaining cover the whole time, which is good.
Bernie,
Then
you
they
need to
deploy a
share
40
that
millimeter
screen.
round. You're not seeing it?
No,
All right. How about now?
there you, absolutely, yes, thank
There we
you.
go. So he's holding a gun to his head. They're holding cover, and somebody's using a 40 millimeter round to stun him, the back and the side. Very effective. He drops the gun and surrenders. Under the wording of our statute, that would not be allowed. So some of these restrictions can be can cause problems for us. Let's continue on. This entire section here, I think, should be really under crowd control. Should be in cases of unruly crowds or riot circumstances. It really doesn't have a play for the average daily officer. So to separate that into some sort of measure of crowd control was really where these sections should be. Use of force to prevent escape. The only change in here is you see that's been underlined, including force likely to cause death or great bodily harm. So whether we're in a penal institution or not, using deadly force to prevent escape is no longer going to be allowed in any fashion, except as above, as he would be justified in using if he were arresting such person for that offense. So this largely affects penal institutions. Duty to render aid is not part of the agenda, so I'm not going to get into that. But duty to intervene. So this new section creates an affirmative duty for officers. Shall have an affirmative duty to intervene to prevent or stop another peace officer in his or her presence from using any unauthorized force that exceeds the degree of force permitted, if any, without regard to the chain of command. Now, no difficulty with the language here, particularly without regard to the chain of command. We do train officers that they should disregard seniority. They should disregard rank when it comes to intervening. The difficulty is there's no language in here that helps us to understand that officers may encounter a use of force that they, without context, don't know whether it's authorized or unauthorized. And that perhaps based upon their belief or perception with the limited information they have, they may not be able to come to the conclusion that's not obviously excessive force or unnecessary force. So having that language in here would be helpful. It's the guidance that we give officers all the time. And there are plenty of occasions where we wish officers would have intervened. So this doesn't change our training. I think it just illustrates that this is a critical issue for us. And as we could see in the George Floyd case, the 3 additional officers that were present, none of which intervened. And in fact, all 3 of the officers were very, very young. In fact, I think 2 of them were being trained by Officer Chauvin. The odds that they would speak up and intervene, even physically, are extremely low. And that we have to train these things to officers to do that without hesitation, to not be concerned about rank or seniority. And then they're adding in a section about agencies shall not discipline or retaliate against an officer who does this. I think that's appropriate, so that agencies cannot look at an individual and because of the culture of that agency, do something to that officer because somehow that doesn't fit into the culture of the agency. For the search warrant section, do we have time to cover that?
Yeah, I know we will need to move on, Bernie. But thank you so
Okay.
much for your insight into that. And we are going to move on to Bob Berlin, who is going to give us insights into the criminal and prosecutorial considerations of the new act. To you, Bob.
Okay, let me just get started here. Okay, can you see that?
Yes, we can. Thank you.
Okay, great. All right, so I'm going to talk about some of the criminal and prosecution considerations with this new bill, starting with the body camera video. Just a little bit about body cameras. Some of the body camera laws, it's already been implemented, but a lot of agencies have not implemented body cameras. So I just want to talk about this briefly, but the bill requires all law enforcement agencies to employ the use of officer-worn body cameras. And there's dates depending on the size of the municipality or county as to when they have to get on board, starting with January 1st of 2022 in counties or municipalities over 5,000. The cameras have to be turned on at all times when the officer is in uniform and responding to calls for service or engaged in any law enforcement related encounter or activity that occurs while the officer is on duty. And there's a definition too, not in this statute, but the definition of in uniform comes elsewhere. It includes officers who may be in plain clothes, but they have a badge or a tactical gear or gun belt or a patch or other insignia indicating that they are a law enforcement officer acting in the course of his or her duties. It pretty much includes all police officers except those who are truly undercover. There are certain requirements when the cameras must be turned off. And that includes when a victim of crime requests that it be turned off, a witness of a crime or a community member who state that they will not speak with the police unless the camera is turned off, or if the officer is interacting with a confidential informant or engaged in community caretaking. In those situations, the camera must be turned off. Here's the big change in House Bill 3653. This was the statute prior to the change, which said that the recording officer and his or her supervisor could access the recordings prior to writing their report. The General Assembly struck the recording officer in House Bill 3653. So now the statute reads that the supervisor of the recording officer may access and review recordings prior to completing incident reports, but not the recording officer. And this came up in a forum that I was at previously in the past couple of months. And Senator Sims, here's what one of the sponsors, here's what he stated. This is clearly what the reason for this change. He said that supervisors are allowed to review the reports. And furthermore, when a member of the public makes a complaint, they cannot review the data before making their complaints. So this provision treats law enforcement the same way. We're trying to put law enforcement on the same level playing field as a member of the public making a complaint. We have had a lot of discussion about this provision, and I know that a lot of police chiefs have said that their officers are going to write the reports indicating that they showed up to a scene, their body camera was working, and see the video for details. And that's really unfortunate, but I believe that is, if this is not changed, that is going to be one of the implications of this particular provision.
Hey, Bob, can I ask a quick question?
Sure.
Susan, how do you see criminal prosecutions going if that's the way the police report is going to be written?
I think it's something that we'll have to deal with at a trial. Obviously, the officer will be allowed at some point in their testimony to explain why. And it may be on redirect examination. If it comes up on cross, we as prosecutors will have to ask that officer, why is it that you didn't write a detailed report? And they'll have to state, because the law doesn't allow me to review it, and I didn't want to make a mistake. So I think I think we'll be able to deal with it. I think we'll be able to explain it. It's just a challenge as prosecutors. It's going to be another challenge for us.
Okay, thank you.
Sure. Okay, so regarding the access to recordings, the recording officer's field training officer has access to review these recordings for training purposes, and the detectives and investigators directly involved in the investigation can access and review the recordings pertaining to the investigation, but they don't have access to delete or alter such recordings. In my opinion, it's very superfluous language because to delete or alter them would be misconduct, and I'm going to talk about that in a second.
Bob, can I ask you a question before you move on?
Sure.
So in going back to that provision about who can review, I understand that there may have been an intent not to allow the officer to not review the recording, but it does not, there's no language in that statute that prohibits the officer from reviewing it, number one. And number two, to the extent that an officer is performing his job and responds to a call or is dispatched to a call, aren't they conducting an investigation?
I think, well, okay. I think the second part of that question is, yes, they are. But I believe when you look at the language that they struck, just the recording officer, and they're still allowing the supervisors or investigators to access the recording, I think they mean to distinguish the two, the reporting officer from the detective or investigator. I think that's my reading of the intent. And while I agree that there's nothing that prohibits, the recording officer from viewing the recording, you have to look at how they changed the statute. They struck that language. They took the recording officer out, and you have to look at what the legislative intent was. And I think here, if you look at what Senator Sims had to say, it's pretty clear what their intent was. So, I would obviously caution, unless this language changes, I would caution against having the recording officer who responds to a scene being able to review the recordings prior to doing the report.
And if they do you think that taints their testimony in a subsequent criminal trial?
It's going to be a fertile ground for cross-examination.
Mhm.
I don't believe it would rise to the level of a judge striking their testimony. But I just, it's something that we would have to deal with. I think the better approach is to just write the report and say, see my video for details. Easier for us to deal with.
Easier for you to deal
I'm
with.
sorry.
Okay.
Easier for the prosecutor to deal with.
So then it's probably important for us as an agency to ensure that all of those reports are prepared or completed before you leave your shift that day. There's no writing a report 24 hours later. I mean,
It's certainly a better practice.
yeah.
Okay, and Bob, we do have a couple of questions from the audience.
Sure.
First, what about squad car camera footage?
I don't believe there's anything in the statute in the new bill that changes that as far as reviewing squad car or in your DUI stop, the videos.
Okay, yeah, because the second question was, would you think this exclusion of video review applies to squad car cameras as well?
No, he just said no.
I don't think so. That's a great question. I mean, it says recordings, access camera recordings. It doesn't really say body camera. It just distinguished body camera from squad car video. That's something we'll have to look at, but that's an excellent question. My gut tells me that there's a distinction because the squad car camera videos are covered by a completely different part of the statute. And that's been on the books for a while now. And it's an exception to the eavesdropping rule as well. I don't know if anyone disagrees of that. If you have an opinion on that.
No, my opinion is that if we can, I don't think there's a direct prohibition, and I would encourage them to look at whatever, assuming that's the chief's opinion. You know, there's a split of opinion as to whether or not officers should look at the body camera video before they write reports. But assuming the chief's opinion is that they should be reviewing the footage, then I would encourage them to look at whatever they can look at in order to be as accurate as possible, which in my mind includes writing those reports as contemporaneously as possible to the underlying events.
As from the union perspective, Yvette, and I'm sorry, Bob, I don't want to take up your time.
Oh, sure.
My concern would be now there's a class 3 felony called law enforcement misconduct if an officer intentionally violates the law regarding body worn cameras. So I would be concerned to allow my member to review it for fear of that being considered intentionally violating the law. Just a food for thought from our end.
Even with a policy?
Well, it says law or policy, so
Mhm.
it needs to be changed.
Can I interject here for a moment?
Sure.
In the course of, I teach reporting as well, including force reporting, and Jeff Chodo and I teach a 2-day train the trainer on use of force. The issue has come up with us on the reporting aspect, and a suggestion has come up that we have do a very, very brief summary. So in other words, a summary of the facts that would lead to the charging of the offense that would have to go to court for a bond hearing, perhaps, or get felony approval. But that leave the portion that might be subject to concern, such as use of force being very broad and general, and having a language at the beginning saying the report was completed in accord with the statute without having viewed any and all cameras, and then doing a later add-on report that would have the details of the force itself, because I think this is the issue, and indicate that the video was reviewed and after the initial report was written, and now this is a supplemental or administrative report on the use of force, and that it has been reviewed with warnings given that viewing of the video was a warning occurred, that the person was warned that they might see things in the video that they have no independent recollection of, and that there be a preamble to each one of those. So we're in the course of creating something like that to meet the statute, but to also have the details that any police chief would want to have in a use of force report so that they can make an analysis, a fair analysis for their officer, whether the force was appropriate, whether additional training is needed. So this is our suggestion, what we're moving toward. I'm wondering if what you thought of that, Bob?
I think it's a good idea. You know, the bill says incident reports or other documentation. And I think once you get past that, I think it is proper, look at the video and just reflect that you're writing a new report after reviewing the video.
Isn't the use of force report isn't it a supplement? It's still considered a police report though.
Well, we would look at it as an administrative report that is separate from the incident report itself involving the crime of the offender that was arrested.
Well, then you've got to, have your use of force review has to be under a separate policy, but then the only other thing is if you're not including specifics in your police report, where are you going to capture all of that information that the officer actually observed that's not on body cam? You know, remember, we're talking about a 2-dimensional, recording of the incident where the people that are there, they observe things, they hear things, smell things, taste things, whatever it is. That's, if you're only doing a summary, you're going to miss all that information. You got to report it somewhere, whether it's in your notes outside of a police report or somewhere, so that officer can use that to refresh recollection somewhere down the road, and that isn't all lost because we've got some provision that we need to comply with or work around. That's,
Hey, folks, not to get too sidetracked on this topic, but, before we come up with too many ways to work around this section or circumvent it, I think that even the proponents now are saying that they never intended to completely restrict. They wanted to leave it up to the department. I'm confident that as we move forward in trailer bill language, that we will flesh that topic out and that it will be different than it is now. So, not to say that that's not the current language, but the current language is obviously confusing because, we all can't agree on that. But I don't know that we're going to come up with a solution kind of in this forum.
Okay, and I do have another question regarding the statute requiring body cameras based on populations. What about organizations such as like college police departments, more like community college or universities, where they're a district to where the community college is served?
Again, the statute talks about municipalities or counties. And it references a population of the municipality or county. I mean, that's a great question. And I'm not sure that what the formula would be.
Mm-hmm.
Take College of DuPage. The College of DuPage Police Department, when do they have to comply? Because the county is over 500,000 people, but obviously the college is not. I don't think the statute really addresses it. Certainly,
Okay, thank you.
I would say by January 1st of 2025, when every department has to be on board, is what I would think. Okay, let me move on because we're going to run short on time. I want to talk about
A little bit
citation.
extra time, Bob.
Okay, citation in lieu of arrest. And this is a brand new provision which says that law enforcement shall issue a citation in lieu of custodial arrest if the person has proper identification for those accused of traffic and Class B and Class C criminal misdemeanors or of petty and business offenses who pose no obvious threat to the community or any person, or who have no obvious medical or mental health issues that pose a risk to their own safety. What does that mean? No obvious threat to the community or any person. This is a new term in the law that there's no definition for. I actually did a brief search in other states to see if they have any criminal statutes that reference the term obvious threat, and I could not find anything. What the definition of that is. I think it's really up to the officer, and I think it would be viewed as a reasonable, under the reasonable officer standard in that situation, is the person an obvious threat to the community or any person? What does that mean for the person in the Target store in one of the aisles yelling and screaming things at people? Is that person an obvious threat to the community or any person? And I think it really depends on the individual circumstances of the situation. And it's unfortunate that there is no definition, but I think as we go forward, this is one of those areas that is going to be hashed out in the courts. The 3 phone calls in 3 hours rule, this is something brand new. They're changing the language from a reasonable number of calls within a reasonable time period to 3 phone calls within 3 hours. And that is as soon as the person arrives at the first place of custody, that's when the clock starts. Now, what's important to remember is this is a right. The person's arrested, they're in custody, they have a right, like any other right. It can be waived, just like they waive Miranda warnings. But that has to be a knowing and intelligent waiver. And I would suggest that that's going to have to be covered, on a video recording of the person. What
Bob,
happened? Sure.
Bob, we do have a question. Is there some confusion on when citation in lieu of arrests take effect? Some say July 1 of 2021, and some believe it becomes effective in 2023.
I think that is 2021 in July. I don't think that's part of the, the monetary bail provisions, which is 2023. And I know there's some disagreement on that. Okay, so going back to the 3 phone calls in 3 hours, the person in custody also now has the ability to retrieve phone numbers contained in their contact list on their cellular phone prior to the phone being placed into inventory. What happens when the phone is actually evidence in the case, as will oftentimes be the case? The ability to retrieve phone numbers, in my opinion, does not mean that you hand them the phone and they get to scroll through and perhaps delete text messages or photos that may be on the phone. The ability to retrieve phone numbers means that you may have to assist them in getting those numbers in their phone. But I would be very careful about handing someone who's in custody the phone when that phone is going to be placed into evidence. One of the provisions that was originally a part of the proposed language in this bill was that there would be a presumption that the statement would not be admissible if this 3 phone calls in 3 hours were violated. That was taken out. So it is the law, obviously, that someone in custody has the right to make these 3 phone calls in 3 hours. But if it doesn't happen and it's violated, it's going to be one factor, and it should be no more or less than any other factor that a judge will have to consider in a motion to suppress statements or suppress evidence that we'll have to deal with. Okay, let me move on here. Let's talk about resisting or obstructing a peace officer, because again, this is a brand new section which states that you cannot arrest somebody for resisting or obstructing a peace officer unless the person was initially subject to an arrest for some other offense. So, some of those underlying offenses could be, let's say, a criminal trespass to property or obstructing identification, as long as there's some underlying offense where there would be probable cause to arrest the person. Then if they resist or obstruct, they're subject to arrest. But I think what they were trying to go after is situations where police arrive on a scene and they're trying to get information from somebody who's not answering, and that leads to a arrest for resisting or obstructing when there is no underlying offense. And again, this is something brand new where, as we go through, unfortunately, with a lot of new laws, we're going to get guidance from the courts. Another brand new statute, we talked about this just briefly earlier, is law enforcement misconduct. And I highlighted those words knowingly and intentionally because I know we've had a lot of discussions on this provision. And I think everyone needs to remember that. And this deals with writing a police report, withholding knowledge of the misrepresentations of another law enforcement officer from the law enforcement employee supervisor. And it includes misrepresenting or failing to provide facts describing an incident in any report or during any investigation regarding the law enforcement employer's conduct. This it becomes a class 3 felony. And it also includes the body camera provisions. Fails to comply with state law or their department policy requiring the use of body cameras. So the question is, will come up, well, what happens if the officer forgets to turn on their body camera? That's not knowing or intentional. That would not be criminal. But the problem I see is there's going to be an investigation anytime that happens, which I believe is unfortunate, but I understand what they're trying to accomplish here.
And
But I think,
Bob, I
yes,
do have a question. It says, how about a family standing in a way of you placing someone under arrest?
a family member standing in the way.
Yes.
Again, if as far as whether they can be arrested for obstructing or resisting, there has to be an underlying offense. That's what the law says, for which the person would initially be subject to arrest. So unless they're trespassing, obstructing identification is another possibility. Just standing in the way in and of itself, I don't think gives rise under this new provision to allow you to arrest them.
Okay, thank you.
Okay. I want to just take a few minutes to talk about the bail provisions, the abolishment of monetary bail, because the bill contradicts itself in numerous places, and I just want to point some of these out. There's a general provision that states detention only shall be imposed when the person poses a specific real and present threat to a person or has a high likelihood or willful flight. Later on, it states that in each subsequent appearance, so every single court appearance, the judge must find that continued detention is necessary to avoid the specific and present threat to any person or of willful flight from prosecution in order to continue detention. But then on page 370, when talking about forcible felonies, where the state can file a petition to hold somebody without bond, it says that somebody can be detained if they pose a specific real and present threat to any person or the community. Now that or the community standard came in at 3 a.m. And I believe the intent was to include it throughout, but that clearly contradicts those first two provisions. And this is something that I have brought up in the, I'm on the Illinois Supreme Court Committee on Pretrial Practices. And I have raised this issue and I'm hopeful that that is going to be cleared up because if it is a real and present threat to any person, that really means that outside of the domestic violence arena, very few people are going to be detained. Again, more contradictions for certain gun offenses. They can be detained if they pose a real and present threat to the physical safety of any specifically identifiable person or persons. On a UUW by felon, that's going to be hard to do. These are detainable forcible felonies, the ones I have listed here. But I think what's very significant is these. These are forcible felonies where probation is an option. And if probation is an option, there's no way that anyone charged with any of these offenses, unless we can show that they're a flight risk, they're never going to be held without bond. So this is again something that I have brought up in this committee, and I keep bringing up the New Jersey statute, which is a very broad preventive detention statute. And I use the example of it may be a class 4 criminal damage to property, a relatively minor offense. But what if the police find that this defendant has a manifesto or a list of people that they want to kill? Now what? Isn't that a person that the judge should at least have an option of keeping in custody while their case is pending? So I do expect that there will be some changes to the bail provisions. And obviously this doesn't kick in until January of 2023. Again, these are the domestic violence provisions, which I believe the statute is actually very good for allowing detention. The problem is at each court date, that's finding that the judge has to make. These are all your detainable gun offenses where the person's release would pose a real and present threat to the physical safety of any specifically named identifiable person or persons. And again, in these cases, we have to file a petition and show by clear and convincing evidence that certain factors apply. And this specific identifiable person language appears here, which conflicts again with that danger to the community standard. So this is something that we're hopefully going to straighten out. And as I stated earlier, when they're a flight risk, it does expand the number of cases where somebody can be detained. So I'm a little bit over my time. The last thing that I wanted to just add, failure to appear in court. Right now, the law is, it's one class lower than the offense that a person's charged with. So if they're out on bond on a class 1, they don't show up in court, they don't show up 30 days later, we indict them on a class 2 felony. Under the new law, it doesn't matter what you're out on bond on, even a murder, failing to show up in court in that violation of bail bond is a class A misdemeanor. So it really takes a lot of the teeth out of our ability to really incentivize people showing up in court. And this is another area that I have brought up that I'm hopeful that we can change.
Great. Thanks, Bob. I am now going to turn it over to Yvette Heinzelman from Clark Beard Smith, and she is going to discuss employer considerations with this new law.
Thank you, Susan. Appreciate the opportunity to speak to all of you today. Unfortunately, I don't have the fancy PowerPoint that my predecessors, Bernie and Bob had. And I'm going to talk a little bit about some of the employer considerations and some of the things that they have touched upon. One of the items that was identified for an employer consideration is the Police and Community Relations Improvement Act, which was amended to allow for anonymous complaints to be submitted to the Law Enforcement Training and Standards Board. And in that provision, I think it's 50 ILCS 727, the Law Enforcement Training Standards Board will take an anonymous complaint and conduct a preliminary investigation regarding issues identified in section 6.3 of the Illinois Police Training Act. In that section, with respect to the anonymous complaints, you know, for the majority of the clients or the entities that I've worked with, when we receive complaints, and even when we received anonymous complaints or information, or we were on notice of information that would give rise to a violation of our internal rules and regulations, the recommendation has always been to conduct an investigation. So whether or not the information comes from a signed affidavit or an anonymous complaint, most of the jurisdictions were already investigating. Now the Police Training Act and the Training Board may also conduct an investigation, or at least a preliminary review and accept those anonymous complaints. Those are going to tie into the issues that are identified in section 6.3b of the Training Act, which talks about, which is a new addition to the Training Act regarding discretionary decertification of a police officer. And so when looking at those issues, setting aside who's conducting the investigation, when you look at what the issues are for decertification, they're use of excessive force, failure to intervene, tampering with a dash cam or body camera, making a false statement, tampering with evidence, unprofessional, unethical, deceptive, or deleterious conduct, causing harm, deleterious conduct, or deviation from the minimum standards required of a police officer. When you look at those items or those categories, those are categories where most police departments have rules and regulations to address, and which may result in disciplinary action. Now with this new section, rightly or wrongly, that may also result in, depending upon the conduct at issue, a decertification of that individual. So these are issues to keep in mind, that not only are you going to be required to conduct an investigation, but that the training board may also be conducting an investigation. So rolling into section 6.3b of the Illinois Training Enforcement Act, there is a section 6.f, which is what I want to focus my comments on with respect to this investigation process. Section 6.3f talks about who conducts the investigation and how that investigation will be conducted. And it provides that the entity that where the officer works, the governmental entity where the officer works, is going to be required to conduct that investigation unless that governmental entity refers that investigation out to another agency, for example, the state police, refers that investigation out to an external agency to conduct the investigation, or allows the training board to conduct the investigation. From an employer's perspective, I think regardless of what provision of this Reform Act you're looking at, I think it's going to be very, very important to have an internal investigation policy that lines up along with this Training Act and provides your officers with assurances that you're going to conduct that investigation internally. It's important to designate an individual that's going to be right down the middle, conduct that investigation, package that, provide notice to the training board that you're conducting the investigation, and then conduct the investigation in a way that is fair and reasonable to all that are involved, regardless of whether or not you have a written complaint, whether you have an anonymous complaint, whether you have a confidential complaint, whatever it is. You want to maintain control of that investigation so you understand how it progresses, what the evidence is, and you can take the prompt remedial action necessary in order to address whatever that conduct is. It's also important to notice that section 6.3 of the amended statute provides that you have to notify the board within 7 days of receiving notice of a violation of any of these rules. So again, very important to have a robust internal investigation process and an individual in charge of that policy that is active and not afraid to take the appropriate action when necessary. It's interesting that the Policing and Community Relations Improvement Act amendments talk about in the second section of that of the anonymous complaint procedure, they talk about the board conducting a preliminary review and if it determines that an investigation should be conducted, they're going to sign a sworn affidavit to override the affidavit requirements in the Uniform Peace Officers Disciplinary Act. You know, while none of these changes are humorous, it's somewhat ironic that they're inconsistent in requiring the board to sign an affidavit when they turned around and amended the Uniform Peace Officers Disciplinary Act in order to remove the affidavit requirement that was in that section. And so I'm going to switch gears here for a moment and talk about the changes to UPOTA as well. To the extent that there have been amendments to the Uniform Peace Officers Disciplinary Act, I don't know that I think that those are significant differences or significant amendments, other than the fact that preventing individuals from coming in anonymously beefing the officer that arrested them just because they can, and they don't have to provide substantiation for those allegations. And I think that, and in that respect, the affidavit requirement was an important part of that process. And if you remember, for most of the organizations that I work with, we never turned over that affidavit. That affidavit was kept confidential until we were in a situation where we were going either to an arbitration or a Board of Fire and Police Commission hearing, and were required as part of section 725/3.2 to turn it over as part of the administrative proceeding. Otherwise, all of those complainant identifications and the affidavits were kept confidential until that hearing process. Following up on the Uniform Peace Officer Disciplinary Act amendments, there's an amendment to section 3.4, which removes the name, rank, unit, and command of the officer that's in charge of the investigation. I don't know that that is a significant amendment for those conducting internal investigations. You're going to have somebody that's in charge of that investigation. They're going to conduct the investigation, formal, informal, conduct the interrogation, and regardless of who they are, that investigation is going to move forward. There's no requirement, therefore, to provide that as part of the notice of proceedings. With respect to the certification requirements for in the amended Safety Act, the amendments to the act provided a discretionary identification of discretionary criteria where individuals can be decertified. And so to the extent that individuals fail to engage in the appropriate conduct, not only can they be subject to disciplinary action, but they can be subject to decertification. And I think I went through those those criteria before. It's the use of excessive force, failure to intervene, tampering with the dash camera, false statements, unprofessional, unethical conduct. And deleterious conduct, so there's a lot of language in this statute that is somewhat vague. Deleterious conduct means causing harm or damage to somebody. A deviation from minimum standards, again, it's a vague standard that is going to be somewhat difficult to pin down. Again, I think that organizations would be well served by having these items rolled into their rules of conduct, so that when we are taking appropriate action, we're taking appropriate action based upon the rules and regulations that we have for our organizations, and not relying on the decertification process for purposes of managing our organization. Another item that to talk about is, or from the employer's perspective to talk about, is the Attorney General Act. And as you may recall, effective July 1st, 2021, the Attorney General Act was amended to ban pattern and practice conduct by law enforcement officers that deprive individuals of their constitutional rights, or persons that are acting on behalf of the governmental authority. And the remedy for the violation is a $25,000 penalty for the first action and $50,000 for the second action. What's somewhat ironic about the amendments to this statute is that it talks about a first instance and a second instance, but pattern and practice of conduct by its definition mean a continuing series of conduct. So pattern and practice, so it happened on more than one occasion. So 2, 3, 4 times need to occur, or incidents that need to occur in order to establish a pattern and practice of conduct. And one would think that it would be based upon a policy either from the organization or from a series of officers acting in concert. So it's somewhat inconsistent with this statute to say that one instance of a pattern of conduct would expose an organization to civil liability of $25,000 for that violation. The other interesting expansion of this liability is that it expands the statute of limitations to 5 years. Investigating a one-off incident that occurred 5 years previously without having some sort of investigation conducted at the time of the incident is going to make it very hard to defend against any of these allegations of one instance under a pattern and practice of continuing conduct. And I see Tamara,
we do-
I'm
Yvette-
sure you have some commentary on this.
Yes, and Yvette, real quick, we do have a question. Is it the intent of the statute that officers must report their training directly to the ILETSB as opposed to the department making that report?
Say that again. Ask the question again. Isn't the report of the pattern and practice statute?
Is it the intent of the statute that officers must report their training directly to the ILETSB as opposed to the department making that report?
You know,
And-
I think the language of the statute talks about the officer reporting, but that would not be my recommendation. My recommendation would be that the department manage through maintain the training records, have a process by which the training requirements, once they're established, are identified for each officer. They verify that each officer has attended that training, so that if at some point in time the officer is questioned about the training that they received, or the department is questioned about the training that they received, that is all maintained by the department. It can be produced by the department, and that there is no question, or there aren't instances where officers have missed training that is required to be reported every 3 years. So while that may be the case, I would not leave that to individual officers at all.
Yvette, before I get to my question, on that point, I agree with you, because it says officers, but it also has very heavy mandates on the employer to maintain that data. So if the employer has to maintain the data anyway, why duplicate the effort? Just have the employer forward the information or do whatever.
Yeah, I would agree wholeheartedly. I certainly wouldn't want to leave the reporting requirements under this new act to individual officers to ensure that it gets done.
Right.
Yeah, and then
Um,
I did receive another comment related to that. It says ILACP asked that, and we wanted the training sergeant to report. Right now, it rests with each officer.
In my question, Yvette, on the back to the pattern in practice, it seems pretty clear that they're trying to sort of give the AG the same kind of power that like the US Department of Justice does to have these pattern in practice investigations like was done in Chicago, for example. So I had an attorney kind of go line by line and compare what the federal guidelines are for federal pattern in practice cases. And the federal cases do not allow or provide for penalties, monetary penalties. It's all injunctive relief or whatnot. Do you interpret this provision for penalties to apply to the municipality or the department, or do you interpret it to potentially implicate individual officers having to pay penalties? I mean, we certainly hope the former is the case, but I think it could be read either way.
Well, if you look at it, while they may have officer in the statute, when you couple that with the indemnity provisions under other statutes, I don't see how you're going to be holding individual officers liable unless you're going to be looking for punitive damages, which I don't even think there is in here, right? So
Right. Well, penalty though, that's kind of a weird. That's not really penalty has sort of a. I don't know. It's something that I think needs to be clarified.
well, if you're saying that penalty may be akin to a monetary equitable relief, I think it's. Like I said, I don't know how you're going to get to the individuals with those indemnity provisions, but I can't tell you that I didn't go through it line by line either compared to the federal statute. It would, from the federal cases are more about remediation,
right,
than anything, than penalty. And this, I think, aren't the penalty provisions, isn't that paid into, it's paid into the Attorney General Court Ordered Voluntary Compliance Payments Project Fund. I don't know what that is, but that's where the money is going to be going. So
Thank you.
I think it's similar to the other statutes that they're working on with respect to monetary liability for the officers. I still think it's covered by the municipalities. Okay. So in looking at, I believe the Attorney General Act, we were also talking, and the one comment I wanted to make, because I think there were some references to collective bargaining provisions. If you look at, stepping back for a moment, there is a provision in that, in the Police and Community Relations Improvement Act about the anonymous complaints. There is a specific reference to the inability of collective bargaining agreements to override that receipt of the anonymous complaints. And throughout the statute, there are references to collective bargaining agreements, the ability to override some of the provisions in the statute. The one thing that is in here that refers to collective bargaining is the residency requirements, which now is a premises subject to bargaining for jurisdictions in excess of 100,000 residents. So other than that reference, there hasn't been much change to the collective bargaining provisions. I wanted to comment on two things that were not on my list, and I know I'm running out of time. One is the mental health screening requirement under this statute, and which requires organizations to provide mental health screenings, periodic reviews. And my comment on that is, I think it's a great it's great to have peer review processes for officers, particularly now in light of all that's been going on. I think that organizations need to select those individuals carefully so that those are not the individuals that we ordinarily use for fitness for duty evaluations and other more in-depth evaluations. Because if they are doing peer review, officer wellness and things like that, an organization may not be able to use them separate and apart for purposes of fitness for duty evaluations. I would also suggest to you that under the Safety Act, there's some references to the Training and Standards Board vetting individuals in order to ensure that they have the backgrounds and capabilities necessary in order to be officers. They don't have the violations that are identified in the statute. Again, I would suggest to organizations that you get together with your Board of Fire and Police Commissioners and make sure that your hiring processes are consistent with what these requirements are, because we want to hire individuals that are compliant with these requirements, that are going to be able to be successful in these jobs. They're going to be able to comply with all of these issues and will not have difficulty, or we won't have difficulty on the disciplinary side. So with that respect, I think it's important that we look at who we are hiring in our hiring processes. The final comment I wanted to make is with respect to the whistleblower protections in the Safety Act. If you recall, there are whistleblower protections with respect to issues, improper governmental activities, which, talk about violations of state and federal law, the abuse of authority, violation of the public trust, danger to the public, and gross waste of public funds is also an item that somebody may report on under this whistleblower provision. I wanted to point out that that provision applies to all public employees, not just police officers. And if we don't have, as a jurisdiction, if we don't have a policy, and if we don't have an auditing professional or an auditing official that's designated by our by the entity, then the state's attorney is going to be your auditing official. And you don't want those complaints to be going to the state's attorney's office. You want those complaints to come to your identified auditing professional. You want them to conduct the investigation, take the appropriate remedial action, and make sure that we can handle those incidents internally so that we take the appropriate prompt remedial action. And with that, I think that brings my comments to a close. Am I within my time allowed?
You did very well.
Thanks.
So we got behind, but you caught us up. So thanks for your comments. Okay, we're going to turn it over to Tamara Cummings, and she is going to give us the employee's perspective.
Great. Hello, everybody. A couple disclaimers. I too am a slacker, and I apologize for not having formal documents or PowerPoints. Secondly, just in terms of my approach, I've been through this bill, 400+ page bill, over and over again with two sort of objectives. Working on trailer bill to fix what you've already heard some, but there are many other inconsistencies and problems with the bill. But secondly, obviously, assuming that we're not successful in some of our efforts to fix language by July 1st, obviously I have to advise my members and to some extent train my members in a way that's consistent with this very confusing and poorly drafted bill. And anyway, my first topic is law enforcement misconduct. Bob did a good job of outlining what that is. It's a new Class 3 felony if an officer knowingly and intentionally does one of three things. The first two things are what I call the misrepresentation categories. So if you misrepresent facts or things in a report, or you have knowledge of somebody else, then you could be subject to a felony charge. And then the third category would be the knowing and intentional violation of policy or the law on body-worn cameras. Now, this Class 3 felony is not a joke, right? It's potential jail time. And even if no jail time, even under the current law, a felony conviction means you are automatically decertified with no appeal rights or anything. So what are my concerns? Well, obviously we don't condone officers lying. I mean, that's not what I'm saying. But what I am saying is even the Brady cases that are out there, they sort of distinguish between little lies. For example, an officer is embarrassed and he lies about how he lost his hat versus big bad lies. For example, an officer lies in the procurement of a search warrant. I mean, obviously that's bad, but the language here is broad enough to include any kind of lie, no matter how small or big. And not only is it overly broad, I think, like a lot of the bill, it's inconsistent with language in the decertification part of the bill. And just, I'm going to point that out a lot, and just a little bit of history here. Initially, the decertification was a part of the bill was a completely separate bill by the Attorney General. And at the 11th hour on the 6th day of session, they quickly combined that with the other many pages of legislation, which is why I think one of the reasons why there are so many inconsistencies. And to the Attorney General's credit, during that 6 days of veto session when this was being discussed, he did speak to us and other stakeholders in law enforcement, and he did make some language changes that we asked for. So I frankly think that the language there is much better in most instances. So the language there, when it talks about false statements, this is how false statements are defined later in the bill. A false statement means any knowingly false statement provided on a form or report that the writer does not believe to be true, and this is the important prong, and that the writer includes to mislead a public servant in performing the public servant's official functions. Now that makes more sense, right? And I think that's the kind of conduct we're looking to remedy or prevent. But what you have here, you have a better, higher standard for decertification than you do for a class 3 felony. And that makes no sense, right? As for the body camera part of it, I agree with Bob. If there's that knowing and intentional prong. If you forget to turn on your camera, that should not subject you to criminal liability. It will, of course, open up an investigation, and they will be many investigations. What I'm more concerned about is, I mean, a lot of municipalities do not have body cameras, and even the ones that do, it takes a while for officers to understand how to use them, when to turn them on, when to turn them off. What if an officer intentionally turns off his body camera, but does not realize or understand that that intentional act was a violation of policy or the law? That officer should not be criminally charged. And I'm afraid that as worded, that's not necessarily not a possibility. So that's my thoughts on the law enforcement misconduct. My next topic is going to be, sorry, I do have some notes. Collective bargaining. A little more history here. I agree with Yvette. The changes to collective bargaining were not huge, especially when you consider that the initial bill as introduced was looking to eliminate collective bargaining for law enforcement on everything but wages. I think one of the good things that happened with this bill, one of the few good things in my humble opinion, is that that was removed. I think the sponsors realized that that was going to prevent passage. However, there is a limitation. And as Yvette said, currently, before July 1st, anybody can negotiate residency unless the population is 1 million or more, which is Chicago, right? That's the only municipality, at least at this point, that has 1 million or more people. Now it's anyone who has a population of 100,000 or more. And that now incorporates 9 municipalities in Illinois, including Chicago. And for those of you who care, that includes Joliet, Naperville, Rockford, Elgin, Springfield, Peoria, Aurora. Of course, the employer is always allowed to voluntarily discuss residency with the employees, but the union and the officers cannot demand that they discuss with them changes to residency. And we certainly can't take the issue to interest arbitration in those jurisdictions under this language. The practical matter, I'm hoping this won't be a big deal. I mean, I think if nothing else, if let's say a place that has very relaxed residency decides that all officers have to move back to town, in a month, I think in a minimum we could demand to bargain over the impact of that, financial and otherwise. And also, I think as a practical matter, I don't think employers are going to go down this road. They're already having a hard time recruiting officers, understandably, in this environment we're living in. And I know, like, for example, in the Quad Cities, there are departments that are actually bragging about the fact that come to our department, you can live wherever you want. You could even live in Iowa. So I'm hoping this is not going to be an issue down the road. So that's all I have to say on collective bargaining. My next topic is UPOTA, the Uniform Police Officers Discipline Act. Again, something touched on by Yvette. For those of you who aren't familiar, UPOTA is simply a Bill of Rights for peace officers who are under formal investigation. Formal investigation means you're facing discipline of a 3-day suspension or more. The changes that, and again, I won't belabor this because Yvette did a pretty good job covering what I was planning to cover. She stole my thunder. You no longer have the right to have the name of the complaining witness or the investigators who are handling the investigation before your interrogation. And there's no longer the sworn affidavit requirement, which is a practical, I am, of course, concerned about this because, I think the one thing the affidavit does do is deter some people from filing false complaints under threat of being charged with perjury. I've never, since the statute's been passed, seen anybody charged with perjury for a false complaint, but I do think it has some deterrent value. And I think maybe we're going to be opening the floodgates to more false complaints, complaints by unscrupulous defense attorneys who are looking to maybe muddy up a police officer on the stand. I also think I philosophically have a problem with the fact that not only are they not allowed to be a requirement, but that we are banned from bargaining over them. I don't like people taking away my rights to bargain things. So that doesn't sit well with me, but be that as it may, we are banned. My other concern has to do with opening the door to this concept of anonymous complaints. And I'm going to get into this here and also when I go into my next topic about the police and community relations impact part of the bill. So, and this again came up when we talked to the AG, Attorney General, about the decertification. Anonymous complaints with substantive, verifiable, supporting evidence are okay in a very limited circumstances. I don't advocate for them. I think they're bad. But I also think that ultimately, if an officer is facing discipline, they should be allowed to confront their accuser. So I really hope that employers don't interpret the ability not to disclose the complaining witness before an interrogation to the right to never disclose the complaining witness, because I think that's incorrect and I think it's inconsistent with other parts of the law and frankly due process, versus a confidential. Because and the Attorney General and I had a lot of conversation about the difference between anonymous and confidential. Confidential complaint means somebody knows who the complainant is. Means they down the road at the appropriate time, an officer will be apprised of the identity of the complainant. And even I think Yvette said that she does that with the affidavits. She doesn't disclose the names right away, but ultimately if the officer's facing discipline, he or she will find out. So to me, that's not anonymous, that's confidential, and that's preferable. And this sort of ties into the Police and Community Relations Impact Act, which specifically allows for anonymous complaints to be filed with a LETSB. this is in direct conflict with the decert, another inconsistency with the decertification part of the bill. As I alluded to earlier, the Attorney General's office and us and I and others had a long discussion about proceeding to a let's be with the decertification case. And with not putting words in his mouth, we were all in agreement that confidential complaints were appropriate. In fact, in the decertification part of the bill, it references confidential complaints because ultimately the officer has the right to know who the complainant is. If that officer goes to hearing and maybe losing his license forever, and that was the understanding. So how this other part of the bill stayed there is beyond me. It's just, to me, this is just an example of sloppy legislating writing, because I can't imagine the AG wanted it, because that's not what he advocated for in the other part of the bill, but here it is. So I frankly think it needs to go. I also, like Yvette, the other instance of sloppiness, I mean, just a few pages prior in the legislation, UPOTA says affidavits aren't required anymore. And now it says to comply with UPOTA, we can do an override affidavit. Again, it's messy. It's just a messy, and this is what happens when you pass legislation in 6 days. You make a mistake. I honestly believe this was an oversight, and I hope I'm right, and I hope it gets removed down the road. Did that have a question for me?
You know what, I'm curious, even with this anonymous complaints, and I don't disagree with you on the anonymous complaint issue, but no, anonymous or confidential, no matter what, if we don't have enough information
Right.
to conduct an investigation, there's a lot of these are going to say insufficient information. There's nothing to do with them, right?
Right.
You need to have enough, and it would be my recommendation and opinion that if we don't have enough information, solid objective evidence to support conducting an investigation, formal or informal,
Right.
there's nothing to do, right? You can't just.
Agreed,
you know,
but you don't
throw-
sit on the training board.
Well,
So
I
don't know
understand.
how you would
but-
treat that, right?
Right, and that's why it's also my opinion that we handle these internally. You
Right.
can handle them in that way, and then you can present that summary to the training board so that you maintain some level of control over,
Yep.
What's going
Agreed.
on.
And that's, I had a little note. I agree with Yvette on this point. Every once in a while, I agree with you, Yvette.
Well, every once in a while, and I would also suggest, I'm going to shout out to the Skokie Police Department because they have a, and I know I've referenced this in my presentations before, they have a sign at their desk that talks about differences of opinion on a ticket and all that other stuff. It's
Right.
something that, traffic tickets are not subject to review by supervisory and command personnel. Differences of opinion as to whether or not a violation took place are best resolved in a court of law. That, I think that sign sort of addresses some of that. I shouldn't have got the speeding ticket for 50 miles over the limit, et cetera. And I think it's an appropriate response to those situations, but anyway.
My last topic, and I think this is a big one because this is very new, at least part of it, is the decertification provisions of the bill. Under current law, and this has been the case for a while, there is what's called automatic decertification. If an officer is convicted of any felony or certain misdemeanors, he or she is automatically decertified, no appeal rights. This bill does expand that part of decertification a little bit. It adds some misdemeanor convictions, like things like indecent solicitation of a minor, criminal sexual abuse, domestic battery, bad stuff. So understandably, they added those things. But they also expanded the definition of conviction. So now conviction doesn't just mean a plea of guilt or a finding of guilt. It means a no contest plea. It means supervision sentence. It means if you get probation. It means if you get conditional discharge. Those are still considered convictions. The big change here is this new animal called discretionary decertification. So I'm going to read basically discretionary decertification conduct is as follow. 1, committing an act that would constitute a felony or misdemeanor listed in this act, regardless of whether or not the officer was prosecuted. So the felonies and misdemeanors in the automatic decertification If you're accused of that conduct but not charged, you could still be decertified. Number 2, exercising excessive force. Number 3, failing to comply with the duty to intervene through acts or omissions. I'm going to read to you another example of an inconsistency between this and other parts of the bill. The definition of duty to intervene in the decertification bill, part of the bill, is different than the one that I think Bernie read earlier in a different part of the bill. Here, it's defined as an officer has an obligation to intervene to prevent harm from occurring that arises when an officer is present and has reason to know, 1, that excessive force is being used or that any constitutional violation has been committed by an officer, and 2, the officer has a realistic opportunity to intervene. I think those are important clarifications, especially when you're talking about intervening in the use of force. That could be dangerous depending on the situation. So that's better, I think. Other bases of decertification: tampering with dash camera or body worn camera data, directing another to or otherwise destroying evidence. Here's how that's defined. I'm sorry, I'm wrong. No definition here. Oh, here you go. Yeah, the definition of tampering with or fabricates evidence. It means an officer has reason to believe that an official proceeding is pending or may be instituted. And 2, alters, destroys, conceals, or removes any record, document, data, video, et cetera, to impair its validity or availability in the proceeding. Very specific type of tampering we're talking about here. Number 5, committing perjury, making a false statement, or knowingly tampering with evidence related to the reporting, investigation, or prosecution of a crime. Again, here the definition of false statement, as I read it earlier, is much better than what I talked about earlier when I talked about law enforcement misconduct. Very specific type of false statement they're concerned about here. And the last basis, and I don't really like this, it's kind of what I call the conduct unbecoming provision: engaging in any unprofessional, unethical, or deleterious conduct or practice harmful to the public. I don't know what that means. To me, it's sort of a catch-all, but it is there. So what is the process? I'll go through this quickly. I know I don't have a lot of time, though I haven't seen Susan, so I have more than 5 minutes. Here's the process. Anybody can notify the training board, or let's be. It could be a chief, it could be a citizen, it could be your mother, it could be anybody. Initially, and it is confidential at that juncture. It is confidential. It's treated as such. There's a preliminary review. And if the board feels there's sufficient information for that requires further investigation, it's assigned to investigation. And like Yvette said, the intent is that the officer's agency does the investigation. However, the board can do investigations, or they can require an agency to do further investigation. Within 7 days of concluding the investigation, the agency has to do a summary report. And if there's reasonable basis to believe the officer committed the violation, then the panel, there's a subset, a panel of the board that's sort of in charge of all this, made up of different appointees. The panel sets the matter for hearing in front of an administrative law judge, and there's requirements for the panel and for the law judge in terms of credentials and all that good stuff. The officer gets notice. There's a default process if the officer doesn't respond. The ALJ has the hearing, makes findings of fact, conclusions of law, and makes a recommendation on disposition. His recommendation or her recommendation goes to the panel, and the panel has to deliberate in closed session, render decision in open session. And this is a good part, I think. The standard is clear and convincing, higher than preponderance. And and a simple majority is all that's required to vote to decertify. Simple majority, clear and convincing vote to decertify. The panel sends that to the board. The board enters a final decision. If the board for some reason disagrees with the panel, the board has to put together very specific written findings as to why. An officer can file a motion to reconsider within, I think it's 10 days. And any decision of the training board on decertification, like administrative decisions, is appealable through Administrative Review Act. A couple things I want to point out. as Yvette indicated, they do provide that there can be concurrent investigations going on at the same time as the decertification investigation. If it's a criminal investigation, the officer can request that the decert proceeding be suspended for up to a year while the criminal matter is being resolved. During that year, the officer's status is considered inactive. There's no such right to suspend disciplinary investigations. So, for example, if you can be at the same time investigated by your department for rule violations as you're being investigated by a LETSB for decertification, they don't have to, for example, limit the hearings to one. So, for example, if I'm trying to put this, I'm talking fast and I'm not making sense. If, for example, a chief fires somebody for just alleged decertification conduct and an arbitrator overturns the termination, there's nothing to prevent the chief or somebody from bringing the same allegations to the decert board, second bite at the apple, if you will. Nothing that prevents that. I would hope that the prior decision would have some evidentiary value in the second proceeding, but it's theoretically possible to have hearing and then another hearing. The decert process is not another thing that's not subject to collective bargaining. So we cannot bargain a different standard or a different process. It's excluded. Inactive status. Now, when you leave your department for any reason, retirement, termination, resignation, you automatically, you being the officer, his or her certification becomes inactive. And this is big because a lot of people leave departments and go work elsewhere. Well, under this law, you'd have to apply to reactivate your certification. And there are bases for them to deny your request. If you were terminated for conduct that would have subject you to decertification, they can deny your request. This is kind of a big one. If you resign or retire while you're under investigation, that could be grounds to not reactivate you. So, you know, you want to retire, you don't think the allegations have any substance to them, you have 20 years on, you don't want to be bothered fighting them, that could still be a basis for denying your reactivation of your certification. Anybody who's denied reactivation has the right to a hearing following the same process that I described earlier regarding decertification. And I think that's all I have to say on that, unless people have questions. I kind of rushed through that because it's a lot, but I have nothing more to say.
Okay, thanks, Tamara.
Thank you.
And I thank all of the other speakers for their insights. I think this was really helpful. And I'm going to turn it over now to Chief Matan from Lamont, who is going to tell us how they're going to fix this. Chief.
Well, thanks, Susan. So I'll just make a few comments about what kind of where we are in the trailer bill process. So that process started Monday. We had a Zoom meeting that was led by Representative Slaughter, who was one of the original architects of this bill. He is genuinely interested in putting together some language. It's just a process to move to that language right now is unclear and maybe a little bit complicated. And we're hoping in the next really 5 or 6 days to clarify that as far as where we move forward to in the process. He did mention that we have about 4 to 5 weeks to get this through. So he's looking at the end of May to have some kind of a product available, and really wants to get something else, some of the financial information before a appropriations committee in about 2 weeks to start working on the costs of implementation of the program. And what I think he's talking to in that is really the body cam section. I don't know that he's necessarily addressing a lot of Bob's concerns about the staffing and infrastructure costs that they'll cause on county state's attorney's offices and public defenders. We have been working, the Illinois chiefs have been collaborating with our other law enforcement partners, including the FOP in Tamara, the Sheriff's Association, to look at some language that we want to fix. I appreciate Bob Berlin helping out on that. And I do want to thank some of the folks that helped Jim Kruger put together this language from our side, and that was his crew of Jim Winters, Jason Aries, Pat Crease, and Jason Parrott that put together the language for our side. So we have that language. It's pretty close to being done, and it's ready to go when we actually get to a point where we're going to sit down and discuss, hopefully, a bill markup process to fix a lot of those sections. And there are still a couple sections like the free phone call bill that we have some proposed concepts, but we're just not there yet with something that we think both sides will accept. So if anybody out there really has some further ideas on how to fix that section, but still, accommodate what the intent was to from the other side to make sure that somebody doesn't sit in jail, they say, for 3 days and never have an opportunity to contact their family. We're open to some additional language there. So I really don't have more than that on the trailer bill process. I have said in other forums that I'm optimistic that we will get something together. There is a moderate caucus that's formed in the House that is extremely prioritizing the fixing of this bill, and I think they're going to ride herd on this and make sure that we do get some kind of a product. And I know they mentioned that they have language coming in from multiple different sources. So one of I think the asks of our president is to let this language move forward from our coalition and versus sending it in from multiple sources, because we don't want to be in a position to be negotiating against ourselves with language that came in from other areas that's not been vetted by the state's attorneys.
Okay,
So-
Chief, we do have a question for you.
Sure.
Has it been addressed with Representative Slaughter, who will pay for mandatory trainings, body camera purchases, and the backbone servers needed, psychological testing for officers every 3 years, etc.?
So on the body camera, I think that the point was made, and he understands the extreme cost of the body camera program. It's way more than the 3.8 million that they've appropriated to the ILETS before. He mentioned on Monday that they were looking to use some of the federal COVID money in this arena, but I don't think anybody really has a good grasp right now of the enormity of how much this is going to cost. So, my guess is we're going to be chasing the dollars for body cameras, and it certainly is one of our goals to try to push the implementation off a little bit on this, but it's not going to be able to be pushed off too long, I think. On the training, let me kind of give you a snapshot of the mantra we've been talking to all the legislators about training for really the last 2 sessions. And so here's what we're asking, and if you have any conversations with your elected officials, here's what we're asking them on the training. And we're asking them to stop this year-to-year addition of ongoing training and mandates to our folks, and 3 hours here every 2 years and 4 hours here every 3 years, and let ILETS be determine every year what the package. So if we decide that the package of training each year for in-service is 36 hours, then the legislature can decide what that 36-hour package is going to be, and ILETS will push out what that package is for 2021, and then there'll be maybe a different package for 2022. But there's got to be some natural end to this. And we're asking them to do the same thing with training. If with academy training, if the academy is 14 weeks, then let's be review every 3 years or 5 years what that 14 weeks consists of, and if some things need to be added, then other things need to be taken away, and to use iLetSP as their instrument and figuring that out. So I don't know if that answered the training, but that's kind of where we're going with the training. We have talked ad nauseum about the impact for small agencies on getting, the entire department through a 4-hour training or an 8-hour training, especially if we have to go to an outside source like NEMR to actually schedule that training. So they've heard that, and it's just a matter of if we got to keep beating that drum until they comply.
Okay, thank you for that, Chief. And then I did have a couple questions that were coming in while the presentation was going on. The first one that I have is for Bob. And it was there was somebody that had stated that the citation in lieu of arrest and the resisting obstruction laws, from what they saw from the IACP bulletin on March 8th, both it looks like it goes into effect January 1st of 2023. Just verifying that.
That is correct. I stand corrected. I went back and I looked at that, and I agree. Both of those statutes don't kick in until January 1st, 2023.
Okay, wonderful. And then if there is anybody that does have a question that would like to pose it to the panel, if you want to raise your hand using that feature through Zoom, I can unmute your microphone and you'd be more than able to speak. Or else you can still continue to use the Q&A function. I do have another question just in general. Is there a way to collectively offer training to police departments, like career training academy provided by the state, so that the quality is uniform?
I think the key on the training is that we have a Illinois Training Board. I think they've shown over the course of a few previous trainings, like the sexual assault and the mental health, that they can put together a virtual class, deliver it online, and that's probably the easiest way for a small department to be able to access training. And really, thank God, several years ago when Irma kind of led PLI into developing a lot of the mandated training into their curriculum, because I think that's been a huge benefit to especially small police departments. And, I will say, iLetSP, probably more than any other state agency is extremely underfunded. They continue to give them new missions without additional staffing and personnel. So I think they're getting a little bit of additional personnel, but not anywhere near all they need for their current missions, much less all the new things they need to take on with this current act. And there's probably 5 or 6 bills that give them additional responsibilities that are bouncing around the current session.
Okay. Yvette, while you were speaking, I believe it was during the new collective bargaining requirement, a question came in. Will this trigger the evaluation of municipality and individual officer insurance coverage due to these changes and an anticipated loss of qualified immunity? Yvette, are you there?
I am. So could you read it? Is the question on
absolutely.
The yeah.
Well,
this. Oh, it's not there.
Yes, based off of the new collective bargaining requirement, will this trigger the evaluation of municipality and individual officer insurance coverage due to these changes in an anticipated loss of qualified immunity?
Are we expecting that we're going to lose qualified immunity or toward? I mean, that hasn't been passed yet. So I'm hope springs eternal that it doesn't go anywhere. So I'm not even thinking about that right now. But I don't. So the residency issue, I've got collective bargaining. If that's what you're talking about, I mean, I've got collective bargaining agreements that have the residency issue. Are you thinking that we're gonna be negotiating in our CBAs for purposes of insurance coverage on the liability side? Is that the way the question is posed?
I'm reading it exactly as it was said, and then it did ask that on the union side, is this a change of work conditions? So, River Forest Conference Room, if you'd like to clarify that, I'd be more than happy to let you speak, or if you'd like to put some more explanation in the Q&A box, we can definitely address that.
Let me just jump in for 1 second while River Forest might add to their question. So the elimination of immunities should not impact insurance coverage at all. So, in the Tort Immunity Act, there's a duty to defend and indemnify public employees for actions within the scope of their employment. We at IRMA have always defended and indemnified police officers that are named in civil rights lawsuits, regardless of the availability of qualified immunity. So I don't see while we certainly hope that immunities are not eliminated in both the Tort Immunity Act or through common law doctrines, it does not have an impact on coverage. There's nothing in our coverage documents that are reliant upon the availability of immunity defenses.
So Margot, that means, so the indemnity provision under state law is separate and apart from the Tort Immunity Act. And I know we're talking about qualified immunity, which is a federal common law concept, which seems to get lost in the shuffle of this. But so, yeah, you would have to not only lose the Tort Immunity Act coverage, which has no coverage for willful and wanton conduct anyway, which nobody apparently is looking at, but then you'd also have to get rid of the indemnity provisions before there's really any significant real risk where you'd have to bargain into the coverage, I think. I think that's where they're going with the question.
Yeah, and I would just like to add that the IRMA coverage isn't triggered by the indemnification provisions of the Tort Immunity Act. So it is triggered by basically a lawsuit being filed against an officer. So honestly, whether or not that indemnification provision is in the Tort Immunity Act, our coverage still gets triggered, even though if that's gone.
It's the coverage document that provides the coverage to the individual officers, which you could theoretically continue to purchase whether or not the Tort Immunity Act is in existence and or the indemnity provision is in existence, right?
Correct.
Yeah, okay.
Okay, and then Bob, I did have a question for you. If you could talk about your thoughts on the trend to release body worn camera video so quickly. Oh, you're on mute.
Thank you. Chicago has their own policy. When they release body worn cameras, my thought has always been to hold off while the investigation is pending. But there are certainly circumstances where if you get a FOIA, you may want to release certain videos or audio recordings to make sure that the wrong narrative doesn't start. So it's really a case-by-case analysis. And every municipality is going to have different policies on that. I don't know if that answers the question.
I think it does. It was just your thoughts, and those are your thoughts, so we're good to go. And I believe that's we've addressed most of the questions that we've had. Again, if there's anything else, we have this opened up right now for you to either ask your questions or type it into the Q&A or chat box. And then I know that Bernie did have a piece that we did cut off. Bernie, I don't know if you want to discuss that any further, as we do still have some time permitted to allow that.
We can. I can pull up and share a document. Can you guys hear me?
Yes, we can.
All right. So I have the section for the search warrants. Let me pull it up. So the change is in blue down below, otherwise the statute 1088 is remaining unchanged. So now we have prior to issuing the warrant, the officer must attest the following things: that the supervising officer will ensure that each participating member is assigned a body worn camera. It follows the policies and procedures in accordance with 10-20, the new statute. Provided the law enforcement agency has implemented a body worn camera under section 1015. If they have not done so, then the officer must attest that the interaction authorized by the warrant is otherwise recorded. So I highlighted that and put it in bold. And I'm guessing that's going to put the onus on the agency or whoever is executing the warrant to find some other method to record it outside of body worn camera or some other fashion. So the question I have to the group is, are you reading it the same way? So it's still requiring recording regardless of the fact that agencies have chosen not to use body worn cameras.
I agree.
So I
Either
don't know.
chosen not to have body worn cameras, or they just haven't gotten them yet.
Right. So I'm guessing since there's no mechanism for that, you could do it in any fashion. You could bring a handheld recorder. You could use a cell phone to record the execution of the warrant, but in some fashion, the execution itself has got to be recorded. And that's the new provision. There's also some things about it ensuring safety, that the plan for other children or vulnerable people on site, so that must be part of the plan. And if an officer becomes aware that it's executed at an address, unit, or apartment different from the location listed, so we have these mistaken cases, must immediately notify a supervisor who will ensure that internal investigation occurs. Probably things that we should be doing anyway. The big thing I see in here is the fact that they're going to have to be recorded in some fashion. And that's it. That's the change in 1088.
Yeah, I think the only danger in that is for let's say SWAT teams, or use a portable video recorder. They typically do not use the audio, and if it's not a body camera, then it won't be exempt from the eavesdropping statute. So that people have to be careful with using some other type of a camera to do that, because it's not technically authorized to audio record.
And one of the suggestions I've heard is that we have a regional SWAT team, that they make body worn cameras available to the entry teams, even if the individual agencies don't have them. So that may be another unfunded mandate. And that's that provision.
So I have a question, if there are none. So Mark, what are the thoughts about whether or not Gillespie is going to even be able to conduct any of these certification hearings in light of funding and personnel and things like that?
I mean, in the short term, I think it's going to be very difficult. I think they're in the process of trying to get staff on board for a lot of these different sections. But I mean, right now, we just sent a letter to them about the responsibilities to put curriculum and training and standards together for the effective date of July 1st. And I don't think that they have, much thought put through to that right now. And obviously our letter was an intent to kind of drive the discussion. It wasn't aimed at Gillespie, but with the intent of maybe pushing the implementation of all of this back, another 6 months or a year until they can get that infrastructure in place.
And I think if I recall correctly, aren't all those positions uncompensated for the panel and the board?
The new boards are, yes.
Yeah, that's what I thought. Yeah, I don't know that from an employer perspective, we're gonna want people sitting on any sort of a paid status that we believe are entitled to be just decertified, and waiting around for some sort of a hearing would be expensive.
Yeah.
Yvette, to that point, one of the things we were advocating was that the disciplinary process be exhausted first, because that would it would basically, if an officer was found not to have conducted by an arbitrator, that would really simplify things, and they have two different things going on at the same time. And, you know, the issue of you having an officer who's sitting at home, paid or unpaid, while, you know, one process going versus the other. It made sense to us to maybe have it, that one has to go first, and then there may or may not be a need for the second one, just depending. Because if you're fired for decertifiable conduct, you know, you aren't going to get your certification reactivated. So why you don't really even need a decert hearing.
Right. I think that's, this process, to me, falls in the same category of what we've had over the last whatever number of years. If you have an individual who violated policy and you also think they might have engaged in some sort of criminal activity, and you report that to Illinois State Police or whatever criminal agency is investigating, or whatever agency is investigating the criminal side, I've never recommended waiting for that criminal process to be exhausted before you start your investigation, right? Because you're going to be waiting forever, and there's no point in going through both of them. And it's always been that we handle our internal investigations ourselves. We get it to a point where we can take appropriate action, whatever that action is, and whatever happens on the criminal side happens on the criminal side. But because that's sort of, from my perspective, sort of I don't think that the officer there should be this police officer misconduct statute. I think some of the items that are under that statute are grounds for taking disciplinary action. But this idea that the criminal proceedings, no offense, Bob, the criminal proceedings are gonna come to a conclusion more quickly than the internal investigation proceedings are, I think is just completely, a misunderstanding of the entire process.
And I'll tell you this without naming specific jurisdictions. This was definitely the resistance to allowing the discipline to take its course is because there are some jurisdictions where the consensus seems to be among certain legislators that the departments just don't fire bad cops. I think that's very few and far between, but that's
I don't represent
that is
them.
definitely they're few and far between.
Yeah.
But I can say with 100% certainty that that's not the experience in the departments where I represent members. But there is this perception that there are departments who, no matter what, are not going to fire bad cops.
Well,
That's like I said, if it is, it's rare.
That's not my understanding of the entities that I've come in contact with either.
Right.
Everybody wants to do the right thing. Everybody tries to do the right thing as quickly as possible because it just, like we know, it's a bad reflection on everyone.
Right. And believe it or not, unions sign resignation agreements. Everyone has this perception that we're like going, full speed for every bad apple. And first of all, this percentage of truly bad apples is small, but I mean, there are times we say, you just have to go, so a lot of this is based on perception more than reality.
Yeah, I think I agree with you that it's based on perception and reality. And I know that you and I have done a bunch of cases and FOP and all the unions. When we conduct our investigations as they are supposed to be conducted, and we have the evidence to support taking the disciplinary action, we don't get to an arbitration hearing. And that's the way it's supposed to run. And that's the way it has consistently run, with the exception of a few. And I can, don't want to name those, but yeah.
Okay, I do have a question for the panel. I know Bernie addressed it earlier, but kinetic impact projectile generally relates to beanbag or KO-1 type rounds. Does the panel agree that the new law extends this to taser regarding targeted impact points?
I would say based on the definition, taser would be included
Yes.
currently.
And did you mention, Bernie, the concern, I mean, about not being able to aim to the back? That's exactly how officers are trained. It's the safest
Yeah.
place to. it's
It is the safest
to take.
place. Taser is suggesting no high chest, obviously no groin, no neck, nothing above the head, and have migrated to suggesting the taser is the best, the back is the best answer. And from a neuromuscular standpoint, it's the most effective location as well. And that if it's included in the statute, that you're essentially making the taser largely unuseful. And then the next question is, what other force would then be used? And the question would it be a higher level of force? I'm sure that wasn't the intention. I think this was all intended to be for crowd control, and perhaps the rare occasions where a kinetic weapon is used, like the video I showed you in that case is a kinetic weapon was used against someone who might have been subject to deadly force, but because they had cover and they had distance and they had protection, they had the time to employ a kinetic energy weapon. So those occasions do occur, but they're rare. But at the same time, had that individual rushed at the police officers, he'd have been subject to deadly force. So or pointed the gun at the officers, he'd have been subject to deadly force. So it needs to be cleaned up. And I think the trailer bill does have, Mark, it includes language that it suggests that it's about crowd control. Am I mistaken on that?
Yeah, that's our intent to introduce that language. And yeah, that's just a consequence of the rush nature of this bill and using terminology that they didn't fully understand. And I think that's their intent. And in fact, the sponsor, Justin Slaughter, has already submitted a separate bill removing taser from the definition of, of those things in the bill. So I'm sure he'll be receptive in the trailer to cleaning that language up.
Right.
Okay, that seems to be all the questions that we have in the queue.
One just came in, Lisa. Did you see that?
Oh, I do. Yep, here it is. Spoke to Taser today. They are not issuing any supplemental training reference Illinois Safety Act. Each department will need to update their training and policies and procedures. It's not really
Taser doesn't take a position on the Taser training. Really isn't about using their weapon. It's about what the weapon does. So I'm not surprised that that was their response.
Okay, and are all officers provided with tasers?
Well, that's a budgetary issue, right?
Yep.
And maybe a philosophical issue as well.
Mm-hmm.
Okay. That doesn't sound like we've got anything else. So I want to thank my panelists again very much for your time. This was great information and very helpful to kind of wrap our arms around this a little bit. So again, thank you for your time. And with that, we can sign off unless Margot has something to say. She popped on.
Oh, thanks
Okay.
everyone.
Okay.
Thank
Just
you.
saying bye.
Take
Thank you.
care. Bye-bye.
Bye, everyone.
Thank you. Bye-bye.